Franklin County Municipal Court is reconvened.
Please be seated. All right, we are on the record in case number 25 TRD 01258, caption the state of Ohio versus Jeremiah Mackey Jr. That's you, sir?
Yes, sir.
All right, so the record should reflect that the defendant is present in the courtroom today. Miss Yeager is here on behalf of the state of Ohio, and this matter is scheduled for a trial to the court. The defendant is charged with 2 counts of involving driver's license violations. One is driving under a OVI suspension, and the other is driving under a it looks like it says security on the citation, but according to the new Albany Municipal Code, it's basically just driving under a forfeiture.
What I have is a financial responsibility.
Yeah. So the driving under an OVI charge, or under an OVI suspension charge, is a first-degree misdemeanor. Carries up to 180 days jail, up to $1,000 fine, and up to a 1-year license suspension. Does carry mandatory minimum penalties of up to, or of at least $250 fine, a 1-day license suspension, and at least 3 consecutive days in Licking County Jail. The other charge is an unclassified misdemeanor, I believe, is it not?
Yes.
Yeah, so it doesn't carry any potential jail time. And either way, if the defendant were to enter pleas of guilty or be convicted of the offenses, they would merge for the purposes of sentencing. So there'd only be 1 conviction. Ms. Yeager, is the state ready to proceed with trial today?
Yes, Your Honor. However, Mr. Mackey informed us he actually wanted this set for a jury trial, not a bench trial today.
All right. And Mr. Mackey, what do you have to say about that?
She is absolutely correct, Your Honor. Also, I shared with her as well. I have documents, if I could serve the court.
Why don't you just tell me what you have there first?
These documents that I have is referring to a removal that's been passed up from the clerk, and as well my case is in fact on an appeal at the moment.
On appeal where?
I'm sorry.
On appeal where?
It's an appeal.
In what court is what I'm saying. Where have you filed an appeal?
The Court of Appeals.
Okay, which district?
The 10th District.
Okay, now that covers Franklin County, and we're in the 5th District Court of Appeals.
I'm sorry, it's the 5th District. You're absolutely right. It's the 5th District.
I'm assuming that your appellate paperwork is similar to what you've been submitting to the court. That's what it looks like.
That one, or this?
But just in general, all of your filings with this court are on this. It's kind of a unique. The documents are unique in that they're gray and they're typed in all caps, and one of them, it looks like, from what you just filed this morning, was filed in the United States District Court in the District of New Jersey in the Newark Division.
Now we're entering a key legal moment. Jurisdiction. The defendant believes filing paperwork in other courts automatically stops this case. But that's not how the legal system normally works. Judges deal with arguments like this regularly, and the next explanation is about to shut that theory down.
You do have the right to have a trial by jury, but in order, in what we call a petty offense, and a petty offense is anything punishable by less than 1 year in prison, a jury trial is not automatic. It has to be demanded. And Rule 23 of the Ohio Rules of Criminal Procedure require that jury demand be made not less than 10 days before the scheduled bench trial. So your request for a jury trial would be untimely. Now, I'll entertain a position from the state in that regard. Do you intend to represent yourself throughout, whether you have a bench trial or a jury trial? Or did you want the court to, or are you going to ask the court to appoint an attorney to represent you?
Represent myself, Your Honor.
Okay. Well, I'm going to go ahead and I'm going to deny what I construe to be a motion to continue for the purpose of setting the matter for a jury trial, because the matter's been pending for quite some time. Let's see, all of February, all of March, and now halfway into April. And so the defendant did have an ample opportunity to submit a demand for a trial by jury, but that demand was made in an untimely fashion today. So the record will reflect that the motion was made, but the court denied that. So your options at this point, Mr. Mackey, are to either have a trial. The state has indicated it's prepared to proceed, and you can obviously represent yourself. You have the right to, if you wish, to change your pleas from not guilty to guilty or no contest. But I do not believe the state is inclined to dismiss the charges. Is that correct, Ms. Yeager?
Correct, Your Honor.
All right. So how would you like to proceed? Would you like to have your trial today, or did you want to change your pleas from not guilty to guilty or no contest?
Your Honor, if it please the court, I motion that this case be continued on or stayed because the case is now on an appeal in the 5th District Court of Appeals. Also, the case has been petitioned removed to the Ohio District Court under case 223 CV 223 CV 02962 JLG CHG and to the New Jersey District Court under case 224 CV 03934 MEFJBC. The court's jurisdiction is divested until those courts determine otherwise.
Watch this closely, because this is one of the most important procedural steps in any trial. The judge is making absolutely sure the defendant understands the right to a lawyer. Courts are very careful about this moment because once someone chooses to represent themselves, the safety net is gone.
Your paperwork from that purports to be from the federal district court doesn't look like pleadings from the federal district court. Those are plain white paper with the case number in blue up at the top of the page, and that's not how yours are captioned. Furthermore, as far as jurisdiction is concerned, this court does have jurisdiction because this is an alleged violation of the traffic laws of the city of New Albany that is alleged to have occurred within Licking County. This court has jurisdiction over traffic offenses that are alleged to have occurred within Licking County. And by being here today and by entering pleas, you've waived any objection to personal jurisdiction over you. All right?
Your Honor, I object on this bench trial. I do want a jury trial.
Okay. And as I've already explained to you, you did not make your demand in a timely fashion, so the motion to continue and the request for a trial by jury is going to be denied. It doesn't sound to me like you don't want to. I know you don't want to change your pleas from not guilty to guilty or no contest. So at this time, I'm simply going to order or ask the prosecutor to call their first witness.
Thank you. The state will call Officer Corse to the stand, please.
Officer, please come forward and be sworn. Oh, actually, before he does that, Mr. You can have a seat. But Mr. Mackey, you indicated that you do wish to represent yourself, correct? Is that right? Okay. So you have the right to be represented by an attorney by hiring one of your choosing. You're also eligible to ask the court to appoint an attorney to represent you at no cost. If you qualified based upon your income, your expenses, your household size, the court would appoint an attorney to represent you. However, if it's your intention to represent yourself, it is necessary to execute a written waiver of the right to counsel. 1258. So I'm gonna have the bailiff hand to you a form entitled attorney waiver. I'm just gonna read it into the record in open court right now. It says, it's captioned attorney waiver, and it says, in open court and on the record, I hereby waive my right to an attorney in this case. I've been fully advised of my right to be represented by an attorney, including my right, if applicable, to have an attorney appointed by the court at no cost if I qualify. I agree to proceed without an attorney at this time. I have been advised of the charges against me and the maximum possible sentence that they carry. I've also been advised if there are any mandatory minimum penalties which might apply. And then it says, in witness whereof I have hereunto subscribed my signature this 11th day of April 2025. So if it is your intention to represent yourself and to waive your right to account to an attorney, go ahead and sign by the X there. But do please read that, because I'm going to make sure that you understand what it is.
Yes, that
I've been objected to this. I object this trial.
I'm sorry, I didn't hear what you said.
I'm refusing to sign this, Your Honor. At this moment, I'm not refusing to sign it.
Now the case reaches the point where facts matter more than arguments. The officer's testimony is simple and direct: expired registration and active suspensions. In court, straightforward evidence like this can be incredibly powerful, especially when there's little challenge to it.
Hold on that, and that can certainly be appealed at a later time. But this part of the case, this portion or this part of the process is going to go forward. If you later appeal, if you're found guilty, I'm not saying you will be, but if there is a conviction that's entered, you have the right to appeal to the 5th District, arguing that this court never had jurisdiction over you, which means basically this would all not count. But you don't get to make I've already made the determination that the court does have jurisdiction over you. If you don't want to sign that form, obviously I can't make you do that, but I will declare what's called a constructive waiver of counsel. And what that means is you've said out loud that you wish to waive your right to counsel, that you want to represent yourself. I'm going to accept that as a valid waiver of counsel, even if you don't wish to sign that. So, Ms. Kyle, if you'll bring this back to me, and for what it's worth, Mr. Mackey, this was filed with the court, and I do have a copy of that, and I did look at it, okay? All right, very well. Please swear in the witness.
You solemnly swear or do you affirm that the testimony about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
I affirm.
Please have a seat, sir. For the record, you're going to give your name and spell your last name.
Officer Michael Coors, Cohrs.
And the address of your precinct.
50 Village Hall Road, New Albany, Ohio, 43054.
Thank you, sir.
Thank you. You may inquire.
Officer Course, how long have you been with the New Albany Police Department?
Over 6 years.
And were you so employed on January 29th of 2025?
Yes.
And were you working that day?
Yes.
What shift or hours were you working?
Second shift, it's 2 p.m. to 10 p.m.
And were you wearing a uniform of the day like you are in court?
Yes.
And were you driving a marked cruiser with a working visible light bar?
Yes.
And what were your duties that day?
I was working standard patrol. I would believe I was on Zone 3, which is the Licking County side of New Albany.
Is that for like traffic enforcement?
Correct.
And what kind of training have you undergone for traffic enforcement?
I was trained at the Columbus Police Academy over 2 weeks of traffic enforcement to include all traffic laws and proper traffic stops and procedures.
And as of January 29th of 2025, were you up to date on all continuing education, training, and certification requirements?
Yes.
I'm going to draw your attention to about 4:50 p.m. Whereabouts were you on patrol at that time?
I was on Beach Road heading southbound just north of State Route 161.
And is that in the city of New Albany in Licking County, Ohio?
Yes.
While on patrol, what first drew your attention to the defendant's vehicle?
As he was traveling northbound, making a left turn onto the State Route 161 westbound on-ramp, I observed he had dark tinted windows, which initially drew my attention. And then as he passed me, I made the right-hand turn, drove behind him, and entered his license plate.
Okay. And did his license plate, when you ran that, return anything?
It did. It turned through my mobile computer, through our leads program on there. I observed that his license plate had expired, or registration, I should say, expired on July 8th of 2024.
And so when you approached the defendant for the stop, did you inform him as to the reason for your traffic stop?
I did.
And did he have anything to say about that?
He stated he was aware that the registration had been expired.
And did he have a driver's license for you too?
He had an identification card.
An ID card? Okay. Were you able to then go back to your mobile unit and run his driver's license status?
Yes.
And what did that return?
I observed, again, through my computer system, that it showed he had multiple active suspensions, one of them being the OVI suspension that he was cited with, as well as the 2 non-compliance suspensions. On my system, the reason why it was shown on the citation as a security suspension, that was the label, but per what I read through the system there, it was the financial liability.
Nothing further for this witness at this time, Your Honor.
All right. So, Mr. Mackey, you have the right to ask this question witnesses. You have the right to ask this witness questions if you wish, but you're not required to. And once the state's rested its case, you'll have the right to present evidence on your own behalf. But this.
And here comes the final lesson of the entire hearing. After the verdict and sentence, the judge speaks directly to the defendant, not just about this case, but about the arguments he relied on. It's something courts across the country have seen many times before, and the judge wants to make one thing clear. Beliefs about the law don't override the law itself.